Okay, we'll bring the meeting to order, the Public Safety and Security Policy and Finance Committee, and start out with a roll call.
Representative Cornish.
You could have a seat, folks, and keep it down. Here.
Representative Johnson.
Here.
Representative Hillstrom.
Here.
Representative Becker-Finn.
Here.
Representative Considine. Representative Dean. Representative Frankie.
Here.
Representative Grossel.
Here.
Representative Howe.
Present.
Representative Lomer.
Here.
Representative Lucero. Representative Newberger. Representative O'Neill.
Here.
Representative Pinto. Representative Ward.
Here.
Representative Zerwas.
Okay, I'll entertain a motion to approve the minutes for February 23rd.
So moved, Chair.
Representative Ward moves the minutes of February 23rd. All in favor say aye.
Aye.
Aye. Opposed? Motion carried. Okay, members, I've had about 4 bills of my own up today, and we might change the order here as we go through. Some of these we'll be holding over and others sending on. The first bill is my House File 184, and that is being held over. The chair will move my bill, House File 184, to be held over for possible inclusion into the omnibus bill. Members, House File 184 addresses a concern we had in Faribault County, where you might have seen it in the media, where a teacher coach had a pen equipped with a camera and left it on a gym bag or something in the locker room and filmed pictures of naked boys. And he did certain things that he did or didn't do with the production or holding of that video dictated on what path the prosecutor had to take. And there was some general misunderstanding of what took place and why, and so we contacted the county attorney, and he was gracious enough to work with us on a fix, what we think we need to do with this offense, so that we could get a more proper punishment and result in the sentences from here on. It wouldn't affect this case, but in the future if something like this happened. So what I'd like to do is bring forward my testifiers, Mr. Troy Timmerman, the county attorney from Faribault County, and the parents of some of the victims of this intrusion and their privacy to the witness stand. And we'll start out with Mr. You can just go ahead. Could we pull up another chair off the end there somewhere? Page, maybe? One more from that side. There will be 4 eventually, maybe here. You can all sit up there if you would. And welcome, Mr. Timmerman. If you would state your name and title and then begin with kind of an outlay of the case and what happened from there. Thank you.
Very good. Mr. Chair, members of the committee, my name is Troy Timmerman. I am the Faribault County attorney, and I did initiate this, I think, actually with Representative Cornish. I had provided him with I emailed him as we were working through this case. And what had happened was, we did have a teacher from the Janesville area who brought his basketball team to Wells, which is in Faribault County. And while his team was showering after the game, he had hidden a camera pen in the locker room. It was sitting on top of, I think, a gym bag or something of that sort. And it was aimed in such a way that he was able to video record young men leaving the shower. The police in Janesville found out about this, and they investigated it, and they determined that there were 4 victims. And as their investigation progressed, they realized that it happened in Wells, not in their own jurisdiction, so then they had to refer the case to me. Now, there are not any ideal statutes for this sort of offense. Basically, we have someone who's video recorded young men leaving the shower. It's not, as many of you might initially think, it's not child pornography. The statutes and case law are very clear on what makes a child pornography, and this did not fit in that definition. It did fit into 2 categories. One is an interference with privacy offense, and the other would be a stalking type offense. And so I charged the teacher with 4 counts of each of those 2 crimes, 1 for each of the identified victims. As the case progressed, I was meeting with the family, and they had some questions that I had to answer. And one of the questions were, for instance, if he's convicted of this offense, any of these offenses, will he have to register as a predatory offender? And the answer was no. And they were kind of surprised by that, as was I when I had done the research. We have a number of offenses that do require predatory registration, but neither the stalking offense nor the interfering with privacy offense require registration. And that was kind of a tough thing to tell them, and I think it was tough for them to hear, because obviously this is the sort of offense that looks like a gateway sex offense. It looks like the sort of offense that's going to start somebody as they might progress. And those are the sort of individuals that I think, at least, that we might want to have registered as predatory offenders. The case progressed, and the other question they would ask me is, well, how long would he be on probation for? Your probationary term is based on the length of the maximum sentence. The maximum sentence for interfering with privacy was 2 years. So that's what his probation would have been for that. Now, the stalking offense does carry a longer term. That was a 10-year term, and that's what we ended up with. But it kind of highlights the fact that we have a crime here, the interference with privacy crime, that can have repercussions that are far more serious than what the penalty is provided for in the statute. And I don't, want to overplay anything here, but you can imagine very easily that these recordings could get placed online, and once they're out there, they never come back. So the harm to the victim far exceeds the punishment that this crime carries. And if you're familiar with the sentencing guidelines, I think this was at a severity level 1. So the interference with privacy is at the bottom. The stalking was a severity level 4, which is better, but it still isn't really all that significant when you consider the repercussions. And I guess that's the extent of my presentation. I can stand for questions, and I know they have some comments they'd like to make as well.
Members, if we could hold questions until the testifiers get done, and just wanted to make sure that we know we're not voting on this, we're holding it over, and we have realized that there are some concerns about the wording in the, and what it includes as a collateral consequence maybe to some other people. So what we're going to do is work on it in the interim after we hear it today before the omnibus bill comes up, and take whatever action we have to allay some of those concerns. So, ma'am, if you would go ahead and state your name and how you related to this incident and begin, please.
My name is Tammy Barnes, and
If you could pull the microphone over.
Sure.
There we go. You can slide right over in front of it. There you go. Thank you.
My name is Tammy Barnes, and I am the mother of one of the victims, and I also happen to be a teacher and a colleague of the perpetrator of this offense. First, I want to thank you for listening and allowing my comments today. In the winter of 2016, this employee and a trusted colleague of mine in the school district was caught abusing his role as a basketball coach to obtain secret nude video footage, and one of them, as I stated, was my son. Our entire family suffered as a result of this. Within the year that followed, we went through a range of emotions of shock, disbelief, and worry, and obviously my biggest concern was the well-being of my son. This is something that a parent doesn't really prepare for, and I didn't want this to traumatize him going forward, so we've spent countless hours having conversations and just making sure that his mental well-being is taken care of. Another component of our healing was going through the legal process, which is something we had not done before, to obtain a conviction. I have to say I was very surprised and disappointed at the way the law currently reads on crimes such as this. As Troy stated, he was originally charged with 8 felony counts and pled down to 4. He only received probation and a jail sentence of 90 days. He served 60 of those days and was just released last week. So this kind of reopened this case for us again. As it stands, the crime doesn't warrant him to register as a sex offender, and I feel very strongly that changes need to be made to include this offense. This crime can allow children to be secretly victimized for years. In fact, if he wasn't caught, this individual would still likely be victimizing our boys. And as it is, he was able to commit this crime at his own admission 40 to 50 times before actually being caught. He could now move into a new neighborhood and no one would know the possible threat that he poses. And although his Minnesota teaching license has been revoked, it's reasonable to assume that this individual could easily gain access to victims in a variety of ways. And unlike sexual crimes that do involve the touching of minors, these victims and their privacy can be violated and go completely unnoticed. But the secrecy of these crimes don't make them any less traumatizing for the victims. In fact, I think the element of secrecy only adds to the feeling of betrayal, loss of privacy, trust, which is something I worry about going forward with my son and his future endeavors. And as long as the law allows perpetrators to remain anonymous to the public, we continue to provide them with easy access to more victims. So on behalf of my son, I would urge you to consider broadening the law to require individuals such as this to register as sex offenders. It's too late to benefit us personally, but this change could quite possibly save countless victims going forward from suffering the way our family has. So again, I thank you for allowing me to speak today.
Thank you very much, ma'am. And now you, ma'am, if you could state your name and your involvement with.
Yes. Good morning. My name is Joan Burns. This is my older son, Ben Burns. I, too, would like to thank you, Chairman Cornish, and the entire committee for allowing us to speak today. My then 15-year-old son, too, was one of the 4 identified on a video in the shower by a camera set up in the locker room by his coach. This man was a highly trusted and respected member of our community. He was a high school friend of my older children, and for my 2 younger children, he was a choir director, play director, teacher, coach, camp counselor, church youth group leader, and a family friend. Never in our wildest dreams would we have suspected him capable of such behavior. You can't imagine the feelings and the emotions we have experienced. We feel part of our son's childhood innocence was taken. He finds it hard to trust and respect those whom he should. As parents, we felt we failed our son. Our children looked to us to keep them safe, and we didn't. This man admitted to doing this, as Tammy said, more than 40 to 50 times. He admitted to sexually gratifying himself while watching these videos, and yet he does not have to register as a sex offender because he touched no one. It is my gut feeling that had he not been caught, eventually a child would have suffered sexual abuse at his hands. The handwriting was on the wall. We need to be proactive, not reactive with these people for our children's sake. While we understand this is an illness, we feel it is progressive, and we are fearful that left unaccountable, the possibility remains very high that our teacher and others like him will offend again. They may move elsewhere, gain trust and respect, and repeat their behavior. The next victims may not be as lucky. He may not get caught before something devastating happens. This is no longer something we just hear about in the news. It happened to us, and it's now personal. We will do everything we can so that other families do not have to go through what we did. Once again, I thank you, Chairman Cornish, and the entire committee for listening to us today.
Hey, sir, did you want to say anything, or you just were here for support?
Here for support and
All right.
the chauffeur.
All right.
Sorry.
Okay.
My brother there was involved, yeah.
Well, thank you very much.
Don't have any.
Members, questions? Representative Considine.
Thank you, Mr. Chair. Mr. Timmerman, in your opening remarks, you made that it's a gateway. Is there something in the literature? Is there some studies that have shown this?
I don't know if there are any studies that
Zimmerman.
have shown that or not. In my opinion, that it would strike me as a gateway type of offense. It seems like that it's a progression.
Representative Considine.
Thank you, Mr. Chair. I'm not disputing whether it is or isn't. When I worked at the Blue Earth County Jail, you used to be a public defender there. I did work with at least a couple of individuals that was their MO. They were peeping Toms. To the best of my knowledge, they never moved on beyond that. But again, I don't have the information. That's what I was asking.
Thank you, Representative Considine. If you notice in your packet, there is a fiscal note, and that's just one of the reasons we're holding it over. So, other questions from members? Representative Hilstrom.
Thank you, Mr. Chair and members. This isn't a question, but previously we have seen this same kind of issue happen. I actually had a bill 2 years ago. It was House File 1433, which dealt with penalties for interference of privacy for folks in the locker room. This committee actually had it in its possession. It failed to become law, Mr. Chair. And so this isn't the first time. This isn't the first place. And Mr. Chair, I hope that we have the ability to actually work on the issue so that it ultimately can take care of the problem in the future.
Yes, Representative Hilton, with your help, we'll maybe form this into a product that we can pass, so by the time the omnibus bill is done. Thank you. Any other questions from members? Anybody from the public wish to testify? Go ahead, come ahead, and if one of you will give up your chair for the testifier there. And you, ma'am, you state your name and title, and go ahead.
Thank you very much. Mr. Chair and members, my name is Sarah Davis. Thank you for the opportunity to testify here before you today. I'm an associate director at the Legal Rights Center in Minneapolis. I'm an attorney. I've been representing people charged in juvenile and criminal court for almost 10 years, with most of that time representing children in juvenile court. I'm here today on behalf of a coalition of juvenile justice advocates to strongly urge you to oppose this bill for a number of reasons. First of all, this bill will significantly expand the net of people subjected to registration and to include people accused of behaviors that are fundamentally different than those currently captured in the registration statute and different than what we've heard about in this fact pattern here today. I want to acknowledge that what's been presented here today is undoubtedly problematic and egregious. But this bill, as it's written, would broadly sweep in a very large swath of behavior, and once registration is attached to a statute, there is no discretion in our law that would allow a judge to say, well, in this case, there was sexualized intent for that interference with privacy, so we're going to require registration. But in this case, there was no sexualized intent, so we won't. That's not how our statute is written, and the problem with this bill is that it would sweep in a whole swath of people without giving any discretion to judges to decide when it might be appropriate and when it wouldn't be. So the question really here today is not whether the defendant in the fact pattern that you heard about here today should be held accountable. I think that's clear, and it sounds like there has been accountability. I'm not familiar with the case, but just based on the testimony. There's a public record. The question is before this committee is whether predatory offender registration should be imposed on a broad swath of individuals with no discretion. So, for example, some examples of types of behaviors that this bill as written would include. A high school junior who does not yet know how to court a partner, okay, a teenager who doesn't yet know how to engage in courtship with a partner, repeatedly texting a high school freshman with what is perceived to fit within a vague definition of aggressive intent or sexual intent. And the case law on that intent is very vague. So that can include this behavior where you have a high school junior texting a high school senior repeatedly because they don't yet know how to engage in courtship for a relationship. A high school student repeatedly calling another high school student who goes to school with them, causing their phone to ring repeatedly or continuously with what is perceived to fit within a vague definition of aggressive intent. Perhaps a group of 14 or 15-year-olds peeping in the window of the house of their 15-year-old classmate with no sexualized intent. Or we could imagine a group of teenagers playing a game where they run around to their friends' houses and snap a photo through the window, again with no sexualized intent. All of these things could be swept up under this and lead to registration. These are just simply not the types of behaviors that are intended to be subject to predatory offender registration. Additionally, I know there was a question about research. There's no evidence or research which shows that registration for these offenses will do anything to promote public safety. In fact, on the contrary, extensive research and evidence indicates that unnecessary registration is actually detrimental to public safety. I'd point members to a report published by the Human Rights Watch in 2013 called On the Record, raised on the registry, the irreparable harm of placing children on sex offender registries in the United States. And there's a lot of research in there about the really significant harms of including unnecessarily including young people on registries. It's also going to lead to expenditure of law enforcement resources to ensure registration, tracking, compliance of more people, but people who actually pose no public safety benefit, or where there would be no public safety benefit from doing so. The addition of these statutes as registrable offenses will likely have its greatest impact on children charged in juvenile court. The behavior covered by these statutes often result of immature decision-making or a need for mental health intervention. In light of everything that we know about brain development, juveniles are by definition most likely to engage in immature decision-making. We know that until our mid-20s, the human brain is wired in such a way as to make decisions based on impulse rather than on rational thinking. For example, looking at the addition of the stalking provision. Stalking is an incredibly broad category of behavior. I'd encourage members to look closely at that statute. It's often reflective of awkward or unsophisticated behavior rather than predatory. I've represented several children charged with under this statute who just simply are engaging in awkward behavior, repeated text messages, phone calls. It's a behavior that might require mental health intervention or counseling. For children whose brains are still developing, their impulsive decision making, when combined with maybe a need for mental health intervention, puts them at great risk of engaging in these behaviors. Expanding the net of registration and to include this means that more juveniles will be subjected to the detrimental, life-altering consequences of registration for behavior that is just fundamentally different than that which the registration statute is intended to cover. Finally, adding these provisions will absolutely lead to legal challenges to the constitutionality of the registration statute. The due process requirement of the Constitution requires that there be a rational basis for the exercise of government power over an individual. There is no rational basis for subjecting individuals to predatory offender registration for the behaviors captured by this bill. Any purportedly rational basis for subjecting an individual to predatory offender registration must be grounded in an assumption that the behavior of that person is in fact predatory. Those examples that I gave you are not examples of predatory behavior, but absolutely would be captured by this statute. Again, we're talking about behaviors like one teenager repeatedly texting or calling another, or peering in the front window of a schoolmate's house with no sexualized intent. There's just simply no rational basis for subjecting an individual to predatory offender registration for this. Registration creates major barriers for education, housing, employment, safety, and more. And Minnesota's registration statute is stringent. Anyone who's convicted or adjudicated delinquent of the enumerated offenses must register. No exceptions, no discretion for the judge. To do this, it's truly bad for public safety, bad public policy, and fundamentally unjust. I just ask you to imagine a teenager you know and care about. Imagine that child is out trick-or-treating with friends. They see the light on in the house of a classmate and spontaneously decide it would be fun to go up to that house and peer in the front window. There's no sexualized or predatory intent here. They just think it would be funny. It's not a decision you or I might make, but their still developing brains is wired differently than ours. Should this child be subjected to predatory offender registration? That is what this bill would do. Thank you for the opportunity to speak.
Representative Becker-Finn.
Thank you, Mr. Chair. I did want to just clarify the part of this bill that would apply to the stalking statute. And it specifies that it would be subdivision 3, paragraph B, which means that it would require sexual or aggressive intent, and it would also require that the perpetrator be at least 36 months older than the victim. So I did want to clarify that. This is a statute that I work with a lot in my other role, so just wanted to be clear that it isn't talking about the 17-year-old and 16-year-old. We're talking about, a 3-year difference with the sexual or aggressive intent.
Okay, thank you, Representative Becker-Finn. Any other questions from members?
Mr. Chair, may I respond?
Thank you very much. What's that?
May I respond to?
Very shortly, yes.
I just would note.
4 bills to go.
Yes, I apologize. I just would note that it absolutely could apply to a 17-year-old and a 14-year-old, which could be a high school junior and a high school freshman. And the concept of sexualized or aggressive intent is really quite vague in the case law. Thank you.
Representative Pinto.
Thank you, Mr. Chair, and this will be quick. I agree with my colleague regarding the stalking piece, I think a fair amount, but I guess I do see the testifier's point when it comes to the the interference with privacy, that it seems like it would, as I look at it, address, it would cover, if there's like teen friends like playing a prank on each other or something, somebody's looking in somebody else's window, which would be a crime, but it seems like that then, as I read this, they'd have to register. So as the bill moves forward, I guess I would encourage that whoever's looking at it work on that, and be happy to do that as well. I think she did make a good point on that one. Thank you.
Okay, thank you very much for your testimony, ma'am. Any other questions, members? Mr. Timmerman, would you come back? Did you have any closing comments to make before we lay the bill over, Mr. Timmerman?
I do not have anything additional, no.
Well, I'd like to thank all of you, and like we said when we introduced the bill, that we realized that there's some clarifications and some changes needed, and we're going to work on it before the omnibus bill comes before us. And so the chair will lay over House File 184 for possible inclusion in the omnibus bill. Thank you very much, all of you.
Thank you.
If we could change the order, the bills here, and do House File 1343 before we move to 1159. House File 1343, Representative Zerwas. You can move your own bill for possible layover for possible inclusion, right? Yeah.
Thank you, Mr. Chair. Members, that'll be my motion to move House File 1343 to be laid over for possible inclusion in the omnibus bill.
Okay, Representative Zerwas, go ahead.
Mr. Chair and members, House File 1343 is a 5-word bill that includes body cameras onto the list of exceptions for transcripts being needed in court. And so currently, if a dash camera evidence is played in court, you don't need to provide the entire transcript for the dash camera within the squad car. This would add or on the officer's person on line 1.12 to clarify that this would also include police-worn body cameras. And so that's the gist of the bill. I have the deputy Hennepin County attorney to provide some additional testimony on the type of impact that current law could potentially have for Hennepin County and other counties as we deal with a new realm of body camera evidence and just the volume of video recordings being submitted as a part of trial to date.
Mr. Brown, good to see you again. State your name and title and begin.
Mr. Chair, members, thank you. It is good to be here again as well. I am David Brown. I'm the Chief Deputy Hennepin County Attorney for the Criminal Divisions. Been a prosecutor for over 30 years now. And when the existing statute was passed, it was done with the idea that squad video was a very positive thing to have, particularly in DWI arrests. And it made sure that when that was introduced at trial, a judge would not say to the prosecutor or the law enforcement agency, if they were the ones that had to produce a transcript, you can't put this into evidence because you don't have a transcript. What we have seen with the introduction of body cameras is an exponential increase in the amount of video evidence that we're getting in. In roughly the 6 months since Minneapolis introduced body cams, and they deployed about 630 of these to their officers, our office has taken in, just on the felony cases, about 5,000 videos. Now, obviously, we narrow that down, and out of hours and hours and hours of video, what actually gets introduced at trial is frequently just a small fraction of that. In Hennepin County, we have a practice that's been adopted into a court rule that says once somebody offers that evidence, they would have to provide a transcript only if the case goes up on appeal. In fact, it requires that it be an accurate verbatim transcript if the case goes up on appeal. That's on whoever offered the evidence. Usually that's the state. And I think for prosecutors, for law enforcement, that makes perfect sense. But to give you an idea, if 10 officers show up and each has body cam on for half an hour, oftentimes we have prosecutors and our paralegals going through that video before trial, and it's not until close to the end that we figure out which 10 minutes do we really, really want. If we have to produce transcript before trial in order to get that introduced, well, now we got to produce a whole lot more. So what this bill seeks to do is to simply treat that body camera evidence in the same way that you have chosen to treat squad video, and that is that in order to introduce it at trial, you don't have to have the transcript before trial. If it goes up on appeal, then at least in Hennepin County, whoever offered it's obligated to produce it, but not before. I would be happy to answer questions about the bill.
Okay, Representative Considine.
Thank you, Mr. Chair. Are the defense attorneys going to feel that they're being excluded or put at a disadvantage? You're talking about just getting that 10 minutes right before trial. Are they going to have the opportunity to review it?
Excellent question, Representative. All of the same discovery rules that is providing all of the video to the defense still exists. This has nothing to do with that. And in fact, in Hennepin County, as of last month, we have worked with our public defender's office where we provide all of that electronically now. And we have a protective order in place with the chief judge that says we can give that to them in the privacy for victims, for other people, is protected in that, so we can give that video over to them before we go through and take out the inadmissible parts, what we call redacting. So we get that to the defense as soon as possible. So they obviously have a chance to look at it. If they want to introduce portions of it, they can as well.
Thank you, Mr. Chair. Thank you for your answer.
Okay, and now we have Sharon Steinbrecher, President of the Minnesota Association of Verbatim Reporters and Captioners. Go ahead with your name and title and begin.
My name is Sharon Steinbrecher, and I am the president of the Minnesota Association of Verbatim Reporters and Captioners, and I'm also an official reporter in the 10th District up in Anoka. This is quite the topic these days. I mean, we're getting a lot of dash cam footage, and it's very important to during the trials. It's important to the police officers and the prosecutors and everyone. The court reporter's role, though, is, and I just want to give you that aspect of it so you know what it means further down the line. The court reporter's role is to take the verbatim record. When they play a dash cam in court in front of a jury, it's usually a very chaotic situation. There's multiple voices. There are, a lot of times struggles. I've had situations where there's emergency personnel working on victims at the same time. And the court reporter, when you're in court, you have the opportunity to stop proceedings and ask to have it repeated if you can't hear, if there's too many people speaking at the same time, so you make sure you get the accurate verbatim record. When they're playing the dash cam footage, that's impossible. It's just being played for the jury so that they get the feel of what's happening and hear it. Normally what's done in our courtrooms in the district I work in, the judges and the proponent of the evidence, they prepare the transcript ahead of time so that they can talk about it ahead of time if there's objections to be made. That's all ruled ahead of time so they know exactly what's going to be played for the jury. That document is marked, and then if the case goes up on appeal, that document is submitted to the Court of Appeals it's a court exhibit to for the Court of Appeals to look at to see what was played for the jury. They will not accept the tapes or the footage at the Court of Appeals. They need a transcript. So it's really just kind of shifting who's going to do the transcript. It sounds like in Hennepin County they have a very good working policy, and that they will provide the transcript if it goes up on appeal. There's just been many cases where that's not done. And in many courtrooms across the state, it isn't done that way. So then it is left up to the court reporter to do this after the fact. Maybe go back to their office when they're doing the transcript and they're playing it over and over again, trying to make sure they get everybody speaking. And what that amounts to then is the court reporter has now made an exhibit that's going to the Court of Appeals. And it might be different than the exhibit that would have been presented by the proponents of the dash cam or the audio. So I just wanted you to understand, the ramifications down the line. It shifts it. I know that there's, staff that has to do this and prepare it. And I would say that, out of the majority of the cases that get filed, a small percentage actually goes to trial, and those are the ones that would need this. It wouldn't be for every case that's filed. So it's just something to keep in mind, and the court reporters would appreciate you understanding that what our role is and how it's kind of a daunting task to have that on our shoulders to be interpreting what's being played. So, and thank you for your time.
Okay, questions from members for the witness? Thank you very much. Mr. Brown, you want to come back? Any response or, okay.
No, thank you, Mr. Chair.
Questions from members? All right, if not, Representative Zerwas, any closing comments before we lay your bill over?
Thank you, Mr. Chair and members. House File 1343 aims to treat body camera video how we already treat video that's currently obtained as a part of evidence, not unlike dash cams and other sources of video. So that's the bill, and I'll renew my motion to have 1343 laid over for possible inclusion in your omnibus bill.
Thank you very much, Representative Zerwas, and with that, we lay the bill over.
Thank you,
Now
Mr. Chair.
Thank you. Representative, my bill is up, I think. Wow, I'm getting a tongue-tied today. House File 470. This bill also, I think, has a fiscal note in it, and we're going to move it to, I'll move my bill, House File 470, to be referred to Ways and Means. Members, in your packet, I think there are a couple of pages for examples. What this bill is addressing is what's come up in the last year, notably as some tampering with a public safety motor vehicle. Someone has been loosening lug nuts on cars. There was a case in Missouri, there was a case in Boston, and then you have some here. There's a State Patrol reminder out that a lug nut had been removed from a trooper's vehicle. And St. Paul PD also had a problem, second such incident in the recent days. And so whether the tampering would be removing lug nuts, cutting brake lines, a number of things, this bill basically acts on whoever intentionally damages or tampers with a public safety motor vehicle is guilty of a felony may be sentenced as provided. And that's probably why the note of the what I'd consider a small fiscal note, but we all got our own opinions, I guess. And this would be put to Ways and Means to decide if we're going to actually fund the bill or not. So with that, I did have an officer coming in, but he couldn't make it. He had another obligation to testify to the bill. Any questions from members? Representative Hillstrom.
Thank you, Mr. Chair. Mr. Chair, I was just having a conversation with Mr. Diebel over here about why it was drafted the way that it was. There is currently a statute about tampering with a motor vehicle, and Mr. Diebel made it very clear to me why he created a separate section instead of modifying that. But I was just simply asking about the definitions. This creates a bunch of new definitions, and it doesn't reference other definitions. They're modified definitions. And so, Mr. Chair, if I could get some clarification from Mr. Diebel, he was just telling me why. Maybe he could answer that question about why they're modified definitions instead of other cross-references to definitions that are currently in the law.
Thank you. And Mr. Diebel, could you clarify?
He doesn't have his file with him, though, Mr. Chair.
Mr. Chair and members, the definitions on page 2 were intended to target critical public safety vehicles, and that interruption in the service would lead to some detriment to the provision of public safety. So there's If there are other vehicles that need to be included, I think that it'd be, I assume the author would be open to adding them to the list.
Mr. Chair.
Representative Hillstrom.
Thank you, Mr. Chair. Then a clarification. When you made the motion for it to go to Ways and Means. Are you planning to lay this over and put it in your bill, Mr. Chair?
On a separate count? I hadn't planned on it. We could certainly do that, but we were going to send it to Ways and Means.
Mr. Chair, I'm happy to work with you on some language, but I think we might need some tweaking, that's all.
We can work on that before it goes to Ways and Means. I mean, as it, before it appears there. Representative Pinto.
Thank you, Mr. Chair. I guess I want to ask about provision, subdivision 1B. As I understand, as I'm saying, so 1A talks about a public safety motor vehicle. Is 1B intended to apply to like private vehicles or vehicles owned by, let's say, law enforcement officers? I mean, it seems like it would encompass any vehicle owned by a law enforcement officer as long as the perpetrator knows that the owner is a law enforcement officer. I guess maybe this is a question for staff, I suppose. I'm just trying to, I can think of some challenges there.
You're correct, it does intend that.
And Mr. Chair, then, so like if, I'm just thinking like, so like a boat or a pickup truck, or I mean, basically it's any private vehicle, whether or not used in law enforcement, for law enforcement purposes, as long as the perpetrator's like, as long as the perpetrator knows that the person is a law enforcement officer, like a neighbor, let's say, who's in some kind of dispute with their neighbor, if they damage their vehicle, they know their occupation, then this would apply in that case.
Yes.
Okay. And so similarly, I guess if the private person involved, or the victim involved, is not a law enforcement officer, depending on the level of damage, it'd be a gross misdemeanor in that case. Okay. And can I understand what the thought is, the justification there in that case, if it's a private vehicle not used, that has nothing to do with law enforcement, and it's not motivated, let's say, by the victim's occupation in any way. The person maybe knows the person's occupation, but not motivated by that. What the justification is for that distinction?
You're correct. And it'd be similar to, I suppose, assault on a regular citizen and or assault on a peace officer, a graduated scale because of the law enforcement connection. Or am I getting your question right?
Well, I think so. So maybe this is a question for staff. I guess I thought that an assault on a peace officer, though, requires, this may be wrong, but requires the peace officer that there be some connection with the occupation in some way. So if a law enforcement officer is there's some assault, something in their capacity as a private citizen, has nothing to do with their role as an officer. And I guess I thought that assault 4 requires that they be somehow that it be connected with their occupation. I can see Mr. Dybel looking that up.
Mr. Diebel, you have a comment on that?
Yep. Mr. Chair and members, yes, the elevated penalties for assaulting a peace officer require that the peace officer be functioning in his capacity as a peace officer.
So I guess that would be the distinction, Mr. Chair, is that in that case, the peace officer has to be in the position as a peace officer. I'm also noticing that this encompasses volunteer firefighters. So as long as someone in town knows the person is a volunteer firefighter, then any damage to their vehicle would sort of elevate their status. So I'm just trying to understand that distinction, because it is different than assault 4 in that way, because the person who's assaulted, of course, it has to be involved in some way that be their role.
Right.
So I guess that's a concern that I'd have as this is moving forward, is just to understand if someone's truly completely acting in their capacity as a private citizen, it's a private vehicle, it's all private. It just so happens the offender knows the person's occupation, then this would apply, and that seems like a concern to me.
Okay. So noted. Representative Johnson.
Mr. Chair, Representative Pinto, I'm glad this is in this provision. A lot of officers don't have take-home squad cars, and they get called in on an emergency situation. So if their vehicle's been tampered with, they will not be able to get to that emergency situation. Same with volunteer firefighters. If they're at the will of when the pager goes off. If somebody's tampered with their vehicle, your house might not be able to be saved by the fire department. So it's important that these vehicles are not tampered with.
Mr. Chair, if I can.
Yes, Representative Pinto.
Thank you, Mr. Chair. And so just to respond to that, as I'm looking at this, any kind of intentional damage of any kind to the vehicle would apply. So it would not require that the vehicle be, I mean, first of all, it certainly doesn't require the vehicle have any connection with the person's role as a firefighter or police officer in any way. And also, there's no limitation. It doesn't need to be that you look at Clause C here, if there's a substantial interruption or impairment of a service, then we're jumping to a 10-year, $20,000 felony. But 1B and 1A don't require that at all. So any kind of damage to the vehicle wouldn't at all interfere with the vehicle being used in any way. So, again, we're getting back to the prior thing. If I don't know, somebody damages the vehicle in some way, knowing, a teenage kid or something like that, but knows the person is a volunteer firefighter, this would apply. Thank you.
Representative Johnson.
Mr. Chair, just a little follow-up on that. You slash the tire, cut the valve stem, that vehicle is inoperable. He cannot get to the firefighter cannot get to the fire. It's a situation like that, bust the windshield. Can he drive it to the fire? But if it's depending how it's broken, he might not be able to use that vehicle because there's a hole in it, in the windshield, and now glass is flying around, making it not safe to respond to that critical incident.
Okay. Any more questions?
Mr. Chair.
Representative Phillips.
Thank you, Mr. Chair. And Representative Johnson, I just want to make it clear, it also would be if you gave my dad a ticket and I keyed your car and your car's perfectly fine, but I keyed it, that would make it a felony here, not counting the value of the damage. So you just have to make certain that you know that I don't think that's what you mean. I think it's about disabling a vehicle.
Representative Considine.
Just clarification, we've had 2 lug nuts taken off in the state of Minnesota. That's what's behind this bill. Am I correct on that?
What did you say? You know of?
No, when you were giving the introduction, you said there were 2 different times that a lug nut had been...
I really don't know how many times it has been. Not something I go...
Well, I was just kind of curious as how that was going to generate a full-time position. They have a FTE here, 1.2 and 1.3 by 2020. What would that person be doing?
Mr. Walls, any explanation for that?
Mr. Chair, Representative Considine, the FTEs are essentially to represent the additional guard time that it would take to look over the additional inmates that would be in a correctional institution. They don't necessarily mean that corrections would go out and hire 1.2 or 1.3 people, but it's supposed to be the additional hours of looking after the people that would be imprisoned by the offense.
Thank you, Mr. Walsh.
Any more questions from members? Yes, Representative Filster.
Thank you, Mr. Chair. Do you commit to working with us between now and the Ways and Means to get this bill in the shape it needs to be in?
Yes, but if you would have noticed it was posted Thursday, you would have ample time to make amendments, and we could have done that today. But yes, I would be interested in working with you.
Thank you, Mr. Chair.
Mr. Hazy wanted to testify. Mark, go ahead with your name and title.
Good afternoon, Mr. Chair, members of the committee. My name is Mark Hazy, and I represent the Minnesota Association of Criminal Defense Lawyers, or MACDL. Please don't take my testimony as any way condoning this behavior or conveying anything but respect for our first responders. They put their lives on the line every day for us, and their safety is paramount. That being said, MACDL does see this bill as being unnecessary and overly expansive, unnecessary and overly expansive increase in criminal penalties. As you've already heard, in part anyways, there's currently a tampering statute that makes tampering with a motor vehicle a misdemeanor. There's also a felony damage to property statute that makes any damage to property over $1,000 a felony. Additionally, within that statute, there's a provision that says if the damage to property creates reasonably foreseeable risk of harm, that's a felony. And I haven't looked at the case law on this, but I would think that removing lug nuts would present a reasonable risk of harm to the occupants of that vehicle. So it's MACDL's position that that most of this behavior is already covered and much of it under a felony statute. There may be some that legislators would like to increase the penalty for that. One option there might be, something along the lines of a gross misdemeanor for things that don't rise to the level of the current felony statutes. And sort of in closing, I just want to mention a couple of things. And one is, ask you to remember the consequences that exist for a felony crime. Those of you that have been here for a long time or otherwise involved in the justice system know about this. Some of you that are new to the committee and the issues may not. A felony has many, many additional consequences that a gross misdemeanor or misdemeanor do not, including removal of the right to vote for the time of a person's sentence. If somebody did, do something stupid when they were 18 or 19 along these lines and they later wanted to become a police officer, maybe they ended up having a good experience, the Post Board does not allow anybody ever convicted of a felony to be a peace officer. That also makes entrance into the military difficult. Not to mention just the stigma around a felony that prohibits, that makes employment and housing difficult, and other things in statute that prohibit people from doing various things once they have a felony. And then just one final thing. Last week there was a discussion in this committee about the effect of deterrence. Mr. John Erickson spoke about that. And I just thought I'd provide the committee, Mr. Valou made copies. There's a sheet in your packet from the National Institute of Justice about deterrence. And I'm not saying that increased penalties never deter people, and the MACDL doesn't always oppose increased penalties, but I ask that when you consider a new penalty and the cost, there's a fiscal cost to this, and then there's the consequent, the potential consequence costs. I ask that you consider if the potential deterrent effect outweighs that cost. Thank you very much for your time.
Thank you. Representative Dean.
Thank you, Mr. Chair. And, I'm looking at this bill, and, I think I referenced this article the other day, too, when we were sitting here. And it's dawning on me that last year we did things that significantly were going to impact our prison population and the reduction. And over the past few weeks, I've seen many bills that are now increasing sentences, moving things beyond misdemeanor to gross misdemeanor to felonies. And this isn't really a question, it's more of a statement. It seems like what we're trying to do is create more crowding in our prisons. And that really concerns me, that that's the direction we're going here at the Capitol. After the work that we've been doing to try to give appropriate punishment, community supervision as ways of actually reducing recidivism. And if the goal is to begin to lock up more people and to create situations where individuals who normally might be able to be directed from committing crimes to sending down the path where they're more likely to serve time and ultimately reoffend, I just question why we call this a public safety committee. Thank you.
Representative Dean, you could help with the overcrowding if you vote for Appleton and prison and open that up. And we're still, I think, very near the bottom on incarceration per capita in Minnesota, so I don't think we're running afoul of our commitment rate to prisons as far as for the rest of the nation. So,
well, Mr. Chair, I think if we continue down this path, we will no longer be close to the bottom of incarceration rates.
We'll see. All right, any other? And I just don't mind putting people in prison that deserve it. I'm sorry, I hate to ad-lib or editorialize too much here, but reminds me of the song with that detective had that cockatoo in his shoulder that used to play. It said, "Don't do the crime if you can't do the time." All right, with that, any other members, any questions? Which one am I at? Where are we sending that? The chair will renew his motion for House File 470 to go to Ways and Means, and before we get there, work with Representative Hillstrom on some amendments, possibly. All in favor, say aye. Aye. Opposed? Okay, now Finally, we make it to House File 1159. The chair will move House File 1159 to be referred to the General Register. Mr. Flaherty, would you approach the table? And any other person that wishes to testify? The House File House File 1159 is a statute to address a problem that has come up on some language in the courts. Back in 2005, we passed the Permit to Carry Act, and within this act was an intention to allow off-duty licensed peace officers to carry in private establishments. I was the author of the bill at one time, Linda Bedreau for a time, I at another time, and I think Larry Hawes at another time, and it was the intention, I believe, to allow this activity. However, there was a case that went through the courts where we had a decision that said that the language needed clarification, and so that's why Mr. Flaherty is here today to help me out to present this bill that would fix the language in this bill to specifically allow what we intended to. Mr. Flaherty, would you go ahead?
Thank you, Mr. Chair. For the record, my name is Dennis Flaherty. I'm Executive Director of the Minnesota Police and Peace Officers Association. We represent about 8,500 officers employed by all levels of government throughout our state. And I'm here in strong support of this legislation, which is designed to prevent the disarming of off-duty Minnesota licensed peace officers. It only applies to actively licensed officers. There's been some recent confusion about the application of the Personal Protection Act to peace officers, and we're seeing sporting and entertainment venues preventing off-duty officers from entering public facilities while possessing their firearms. You have to understand that most cops carry a firearm at all times. They understand and fully expect to intervene or respond whenever they witness a crime in progress or see a person in need of protection. They cannot do so without their firearm. I need only to call your attention to the lone wolf terrorist in the St. Cloud Mall. If this attacker had not been encountered by the trained, armed, off-duty peace officer who was capable of confronting him, the attacker would certainly have harmed or killed many more people. Cops make arrests, they stop crime, and protect citizens frequently all across the state while they are off duty. Citizens, in fact, expect them to take action in these situations, and I think they would definitely support this needed clarification in our law. Officers also come across people that they may have previously arrested or jailed. They need to protect themselves. The boldness of individuals and their willingness to confront cops on or off duty has increased. Lone acts of terrorism are increasing across the country, and we need cops to be able to respond immediately and do what they are best trained to do and do it proficiently. The bill is absolutely necessary so that our officers are not disarmed and are able to protect the public and themselves. And I'd be glad to stand for any questions.
Members, questions for the testifier? Representative Newberger.
Thank you, Mr. Chair. Mr. Flaherty, I am a co-author on this bill, and I like what it does. I agree with every point you've made. The only thing I'm looking at the bill language, line 2.7, you have, and I don't know if this is even an issue, but that's why we have committee. It says the owner or operator of a private establishment may not prohibit the lawful carry or possession. Would it be more prudent, Mr. Chair or Mr. Flaherty, if we tightened that language to change it from may to shall? I just want to make sure that everyone that reads this is crystal clear on that. And as you know, sometimes people, they see things that aren't there. Perhaps I am too, but in this case, I'm wondering just to make this absolutely clear If we should, as this bill progresses forward, maybe wordsmith that to a shall.
Director Flaherty.
Well,
Or
I
it
guess
must.
I really would refer to your counsel on shall or may. I've seen it done both ways. Obviously, we'd prefer whatever is the clearest and,
Mr. Diebel, any ideas? In your history, has it made a difference? May or shall, would it get us into any difficulty?
Mr. Chair and members, I don't see a problem with the draft as presented to the committee. It's, the sanctions under this statute are actually very limited as far as when you do violate it. So the recourse is really a lawsuit. So I don't have a strong opinion one way or the other as to whether it should be may or shall. And my experience doesn't indicate that may is any less effective at reaching the result that the author intends.
Representative Newberger.
Mr. Chair, thank you, and Mr. Diebel, thank you. And again, like I said, I really like this bill. I think it's a great bill, and I don't want to send it along with any possible cracks in the language. That's all. I will defer to your judgment.
Mr. Flaherty, I suppose if we change it, then we're going to have to track it and send it with the same change. Up to you folks. What do you like to do?
I'm talking to my counsel here, and it's really totally up to the committee.
And we have to get the okay from Representative Hillstrom, because we usually, any substantive change, we don't do it unless it's given you notice. So what would you think?
Well, Mr. Chair, I don't believe that it's a substantive change. I believe the intent is the same. I recommend that you pass the bill the same off the House floor and the Senate floor. So, Mr. Chair, if you believe that you need to do it, maybe talk to your Senate author and get it the same and have the agreement before you pass it, because I don't think this is a kind of bill we should pass multiple times on the House floor. We should just pass it, send it to the governor.
Like it is, you're saying, or what shall?
Either way is fine. Just make them the same in the House and the Senate.
Why don't we just leave it for now?
I think that would be fine, certainly with us, if you just left it.
Any other comments or questions? Representative Becker-Finn, followed by Representative Considine.
Thank you, Mr. Chair, and I just wanted to thank you for carrying this bill. I'm happy to support this and sign on to this, and just wanted to add that the officers that I work with, it's not like they stop being police officers when their shift is over, and so I think it is an important public safety issue and something I have heard individual officers have concerns about whether they can continue to have to carry, when their shift is over. So just wanted to thank you for bringing this forward.
Thank you. And Representative Considine.
Thank you, Mr. Chair, and I am also a co-author. Licensed police officers are the people that I want to have guns.
Okay. Any closing comments? Public testimony? Anybody want to? Okay, without any, Mr. Flaherty.
No, I just, Mr. Chairman, I thank you for bringing this forward, and I thank all of the members for the support for this, because it is very important to us.
And thank you for your testimony, Director Flaherty. So the chair will move House File 1159 to be referred to the General Register. All in favor say aye.
Aye.
Opposed? All right, members, we have got 2 bills left, and if we don't finish them, we have to come back this evening, so I don't think we'll have a problem. We don't usually jabber too much on our bills. So House File 915, this is the Corrections and Military Affairs Deficiency Funding Provided and Money Appropriated. And to have so the chair will, where are we sending this? Ways and Means. Chair will move House File 915 to be referred to Ways and Means and offer an amendment, the A1 amendment. And members, what this bill, this amendment does is delete the military affairs section from the bill, and that'll be taken up in another bill. So I didn't know why that came here. Representative Hillstrom.
Thank
Thank you, Mr. Chair, and I don't have a problem with the amendment. Do we know yet what we are doing in terms of timing, in terms of these deficiency bills? Because it's my understanding that this money's needed by April.
That's what I've heard too, but I don't have any information on when we're going to act on it.
Thank you.
So the A1 amendment is before us, the House File 915. Everybody understand the amendment? All in favor say aye. Aye. Opposed? All right, Commissioner, do you want to speak to your bill?
Mr. Chair, committee members.
And it can be fairly short because we've already had a kind of a presentation. Go ahead.
Good morning. Tom Roy, Commissioner of Corrections. In the interest of not jabbering too much, we will move through this with great haste. If you recall from our budget presentation a couple weeks ago, we did talk about our deficiency regarding our 17 medical budget. We have experienced a deficit of, or a shortage that we anticipate and need 9.2 million. With me today is our medical director, Nan Larson, who can speak to the specifics of our request. But generally, we are experiencing the same healthcare costs and increases that all members of our society seem to be facing these days. And our population experiences those medical concerns at a greater rate. And I believe you have a handout that is colorful and looks like this, and that addresses some specifics and some details. But I will, at this point, turn it over to Ms. Larson, and after her presentation, we will gladly answer any questions.
Ms. Larson, go ahead, your name and title.
Good morning, Mr. Chair. Thank you. For the record, my name is Nanette Larson. I'm the Health Services Director for the Department of Corrections. Just a quick bit of history for those of you who are not familiar. Our Centurion contract covers the following. They cover on-site primary and psychiatric care, inpatient if it's not covered by Medicaid, and outpatient hospital care, specialty care like oncology, dermatology, orthopedics, ancillary care such as physical therapy, occupational therapy, speech therapy. They do our utilization management, similar to what you and I would go through in our primary care clinic. They do claims adjudication for us, and then they also provide pharmacy services. The majority of the contract cost increases, as the Commissioner mentioned, are a result of pharmaceutical cost increases and the unique healthcare conditions that our offenders have. Pharmacy costs, for example, if you look at the top 100 offenders in our system, those top 100 offenders cost about $5 million, just their pharmacy costs. When you add in the medical costs, it becomes about $5.5 million. If you look at the handout that we have, on one side, it says drivers of Department of Corrections healthcare costs, and you can see some of the conditions that we've chose. Our incidence in our system is much higher for diabetes, much higher for HIV than the general population. We haven't even mentioned hepatitis C, and as you know, hepatitis C pharmaceutical costs are huge. So we have a really sick population. We don't get to choose. We say this all the time. We don't get to choose who comes to us. If somebody comes to us with cancer, we have to take care of them. If somebody comes to us with dialysis needs, we have to take care of them. If they need a bone marrow transplant and it's a community standard, we have to take care of them. So our contract costs are a little bit higher than what we anticipated. So I think I'll stop there and answer whatever questions you might have.
Members, questions for the deficiency budget? Public testimony, anybody in the crowd? Okay, seeing none, thank you very much for your presentation. And House File 915, motion to refer to Ways and Means as amended. All in favor say aye. Aye. Opposed? Thank you very much, Commissioner.
Thank you.
Now, House File 742, Representative Zerwas, you know where the bill is going and make your own motion when you get up to the table. Any amendments? Representative Zerwas, I don't know if you knew we were planning on laying this over.
Yeah.
It's House File 742. And do you have an amendment? You can move your bill.
Mr. Chair and members, I'll move House File 742 be laid over for possible inclusion in the Public Safety Omnibus Bill. There is a DE1 amendment to get the bill in the shape in which we'd like to discuss. I'd move the DE1 amendment.
Okay, Representative Zerwas moves the DE1 amendment to House File 742. You get it in the shape he would like. All in favor say aye. Aye. Opposed? Okay, to House File 742 as amended, Representative Zerwas.
Mr. Chair and members, being with the hour, I'll be brief in presenting House File 742. According to the Star Tribune report, over the past 10 years, 17,500 Minnesota inmates were placed in solitary confinement for disciplinary reasons. While we cannot say definitively how many of these inmates live with mental illness, 14% of Minnesotans placed in solitary confinement were recommended for state-ordered mental health treatment, which is also known as civil commitment. Even by this narrow measure, it is clear that inmates living with mental illness are disproportionately subjected to segregation. Since 2010, nearly 700 inmates have been released from prison directly from solitary confinement to the general public, according to the Department of Corrections. Research indicates that solitary confinement has a debilitating effect on inmates, especially those living with mental illness. At least 30 other states have taken steps like these to reform the use of solitary confinement. My bill will help keep Minnesota from falling behind. NAMI and I have worked with the Department of Corrections to try to address their concerns from our original language. It should be noted that the fiscal note on this bill is a fiscal note that was put together on the original language and not the DE that was just adopted. That fiscal note that will come out based on the new language should be significantly lower. And so our hope is that we will be able to find a way to enact the amended language as a part of the bill moving forward. At this time, I'll ask John Stewart, who's working with NAMI Minnesota, to walk through the bill.
Friend, Mr. Stewart, go ahead.
Thank you, Mr. Chair and members. My name's John Stewart. I'm an attorney in Minneapolis, and I've been doing some work for NAMI Minnesota this year on bills relating to criminal justice. Starting at the top with subdivision 1 of the DE1, the first provision authorizes the use of solitary confinement. It might seem odd, but right now there's no law governing the use of solitary confinement. And it seemed, as we were talking about this among ourselves, that elected officials should have some input into the use of this major sanction, which affects people rather seriously. This is one of the sections that was amended partly to deal with some of the Department of Corrections concerns about safety in the institutions. The amendment adds escape and major rule violations as the grounds for putting somebody in solitary. The major rule violations include terroristic threats, extortion, smuggling, hostage taking. They really are major serious rules that affect the safety of the institution, so that's in there. Subdivision 2 is the conditions in segregated housing. The two to highlight here, one of them is that currently the inmate gets time out of cell 1 hour a day, 5 days a week. And with this bill, they would get 1 hour out of cell 7 days a week. So it's moving from 5 to 7 hours out of cell. The other thing that's in here that would be a change from what they do now is reduced lighting at night. Of course, the people that are making checks have to be able to see the person, so there's going to be some lighting, but it would not be full daytime lighting. Subdivision 3 is a provision for the warden and in some cases the commissioner to sign off on a person's continued status in segregated housing. And in meeting with the department, they wanted to have the deputy or assistant commissioner also be empowered to sign off when a person is in solitary for more than 60 days, so that somebody in leadership is keeping an eye on the case. Subdivision 4 is for graduated sanctions for rule violations, so that for the less serious rule violations, a person might have loss of privileges, or they might have their motion restricted within the institution. In some cases, the inmate would be reclassified to a higher security place. They're working on that already. The mental health assessments are, we had said prior to placement in segregation, but in many situations that's not practical. If there's, for instance, a couple of guys in a violent encounter, they would have to be isolated before there would be any assessment of anybody's mental health. But the department told us that it would be feasible in most cases to do it within 1 business day of the person's placement in solitary. And if a serious or acute mental illness is found, then the person would be treated in some manner more responsive to their mental health needs. That's the 14% of people, or the 11% that are said to have serious and persistent mental illness. This is actually kind of a cost savings from the original bill, because the original bill would have required them to be put in a secure treatment unit, and those secure treatment units only exist at Oak Park Heights. So this just requires them to think of an alternative, which in many cases would be back in the general population but getting extra psychological care. Subdivision 6, the daily check. This is something that they do already, and there's a little more guidance there. If the nurse who's doing the check finds a problem, they go to the medical director in the institution, and they have the ability to recommend, not to order, but to recommend, again, an alternative setting responsive to the inmate's mental health needs. Incentives to return to the general population. This is something that is going on in many, many states where a person can get a shortened stay in solitary confinement if they obey the rules while they're there, and the department is working on this already. Discharge from segregated housing is an issue because there have been many cases where people's sentences expired while they were in solitary confinement and they were released out to the street. And you can imagine that if you've been for weeks or months living in about an 8 by 10 foot cell by yourself with 1 hour out a day, and all of a sudden you're back out on Main Street, that it's going to create some problems for the person. And this is to provide for more transition, and to have the transfer out of solitary confinement also trigger a mental health review if the person has been in solitary for 30 days or more. Finally, subdivision 9 is reporting, so that the chairs and the ranking members of public safety and security and judiciary get information every year about the numbers of inmates placed in segregation, their ages, what they were placed in there for, the transfers from segregation to mental health care, and the length of terms, including the length of terms served consecutively, because it is an issue that leads to some long stays, that there are many infractions that pile up. So, Mr. Chair and members, that's the DE1.
Okay.
Mr. Chair, Sue Aberholden from NAMI, Minnesota, I think has a testimonial from a family member.
You have something that Mr. Stewart didn't cover? Go ahead.
Mr. Chairman, members, Sue Abderholden, NAMI, Minnesota. I have a letter from a mother whose son was put into solitary confinement who couldn't be here because of work. So I would like that to be distributed if possible. And also just want to say that we've worked very hard to look at what was happening in other states across the country, what some of the best practices were, and really tried to address the Department of Corrections concerns as well. And so we'd really urge you to support this bill. Thank you.
Okay, thank you. Questions? Representative Considine.
Thank you, Mr. Chair. Representative Zerwas, can you give me a breakdown of those full-time positions? Are those all going to be guards, or are we going to get some clinicians to work with the people in there too?
Mr. Chair, Representative Considine, members, as I mentioned in the intro, the fiscal note that is, if it's in your packet, is based off of the base bill and not the DE1. So that's the FTEs involved in the language that we adopted as part of the DE1 will be significantly less. And so how that will break out, we'll have to wait until there's a new fiscal note prepared by staff.
Would you anticipate that some of the positions would be for clinicians?
Mr. Chair.
Representative Zerwas.
Mr. Chair, Representative Considine, members, it's anticipated that there would be mental health professionals, clinicians added, as well as increase security staff. The really intensive part of the original bill is the staffing for having people get out of their cell more frequently. That's a significant cost driver for staffing that within the segregation unit. We brought it down to basically 1 hour a day, and that will be require less of that security staff.
Representative Considine.
Thank you, Mr. Chair. Mr. Walsh, I see you waving your hand. Did you have a comment?
Mr. Walsh.
Mr. Chair, Representative Considine, although the fiscal note, as the Mr. Zerwas or Representative Zerwas said, would come down from the original bill, on page 4 of the fiscal note there is a breakdown of the FTEs, and there are 4 categories of behavioral mental health personnel and a total of 45 FTEs in that classification.
Representative Considine.
Thank you, Mr. Walsh.
Representative Pinto and then Representative Dean.
Thank you, Mr. Chair. I want to thank Representative Zerwas for taking this on, because this is a really powerful issue, but one that'd be pretty easy to not put the effort in. And so I thank you for doing that and pursuing this. And I also, in connection with that, want to thank and recognize the Star Tribune for having a series and pushing on this, just like they did on child protection the prior year. I think it really shows the power and the need for a free and active press, because they really have led the way on those issues. And then just had one tiny point. I noticed line 1.11 says 7 hours a week. Line 3.1 says 1 hour a day. And I was just going to suggest it might make sense to have on line 1.11 to say 1 hour a day out of cell. If that's the goal, is to make sure that somebody gets at least an hour. You could imagine something where somebody gets 3 hours one day and not. In any case, both for consistency and also because I think that 1 hour a day is more the goal. I might suggest as this move forward that if you're making other tweaks, you might tweak that as well. Thank you, Mr. Chair.
Thank you for the comment. We'll review that.
Okay, Representative Dean.
Thank you, Mr. Chair. And this is to the bill author, Representative Zerwas. As I look through this and then I look at the letter that came from the mother of someone that's locked up, there's reference to the state ombudsman for corrections that up until 2002 existed, and then it was defunded. Is that something that you looked at in going through this bill to sort of add that sort of piece in between the folks that are being locked up in segregation and the DOC? If someone could speak to that, I'd appreciate it.
Representative Zerwas.
Mr. Chair, members, I think Sue Aberholden from NAMI can address that
What's
issue.
that?
I think Sue Aberholden from NAMI
Okay, and then we have 3 more people to bring up, so we've got to move along. Go ahead, ma'am.
Yes, Mr. Chairman, Representative Dunn. We actually have another bill that would have included the ombudsman along with some other things, although we know there is a lot of opposition and, of course, not very much funding to create another ombudsman, but we did address it in another bill that actually Representative Zerwas is carrying.
Thank you, Mr. Chair. Representative Zerwas, let's chat about your other bill.
Will do.
Okay, Mr., or is it Pam Caligliari? Something like that? Pam?
Thank you.
If you want to give your name and title and take just a couple minutes if you could.
Hello, my name is Pam Caligliari, and I support this bill. I am representative of the Jewish Community Action Group that is feeling very strongly about the use of solitary confinement. I feel personally that the use of solitary confinement is a form of torture. It goes way beyond punishment to actually severe inhumane treatment and even cruelty. The Center for Victims of Torture states that under international law, any amount of time over 15 days in solitary confinement is considered torture. I would like to see this bill strengthened. I would like to see more oversight to monitor the Department of Correction and how it complies with this. And I would also like to see penalties that the Department of Corrections will face if they do not abide by these rules. And then I would like to read for you excerpts from a piece written by a young man who at 20 years old spent 600 days in solitary confinement in Minnesota State Prison.
Is it very long? Otherwise, you could furnish it in writing and we could read it, but.
Well, I don't have a free copy, but I can provide you with one. I'm just saying I personally went through and highlighted in order to shorten what I could tell you. So I don't even have a clean copy that I could print for you today.
Okay.
This is, Robert Ives wrote this as he was in solitary confinement, struggling with his own sanity day to day for 600 days. My trepidation turns to genuine fear as we stop at an empty cell. I don't want to enter the room, but I know I have to, either willingly or by force, so I hesitantly step inside. They begin the procedure of taking off all the chains that confine my body. It feels good to be free from all the bondage of the chains, and my fear begins to fade as a sense of relief comes over me to finally be alone. I sit down on the bunk and lay back, looking at the ceiling with thoughts of regret on my mind until I fell asleep. The last thing I remember feeling is that sense of release. I embraced it. But what I didn't know was it would be the last time I would feel relief being alone, because it would turn out to be the last physical contact I'll have with another person for almost 2 years. When it comes to lighting in solitary confinement, the opposite of what most people envision as the whole, the lights stay on 24/7 and it's never dark. I've become accustomed to tying a tube sock around my head every night to block out the light just so I can sleep. However, the escape of sleep comes with its sacrifice. The pressure from the sock tied around my head causes my persistent headache to wake up with me each morning. But when you take the trade-off into consideration, headaches or no sleep, it's a sacrifice I'm willing to make. There are no fences, concrete walls, or bars that are trapping my mind in this cell with me. If I allow it to wander too far, it won't return, and I'll risk losing it forever. Losing your mind is a sickness like being eaten alive by a parasite. It eats at you slowly like cancer, spreading throughout you, mutating as it affects your entire body. I realized how critical it is to focus all my energy on not letting that infection spread throughout me. Otherwise, it will. I need to do all I can to continue reinforcing the invisible fence that I've constructed around my mind to contain it. I'm left with nothing but my cell and my imagination. Upon really taking in my surroundings, I begin to count the bricks. I can tell you exactly how many bricks cover the surface area of my cell. 402 concrete cratered institutional gray painted bricks. Bricks that are getting to know me personally. I grab a piece of paper and tear it into strips and fold them into 11 even folds so I can mark inches on them and tape them together with the sticky side of the label for my deodorant. This is my measuring tape. I use it to measure the length, height, and width of the cell. With a sink, toilet, and shower built right into the cell, imagine living in your bathroom for 2 years. Another thing I do is play chess. I make the chessboard by drawing lines on a piece of paper and shade the squares with my pencil. I make the pieces by tearing little pieces of paper and write the names of each piece on them. I place the board on my bed and sit on one side to make a move. Then I get up, spin over to the other side, and make a move to counterattack myself. I do this over and over and over for hours at a time, alternating offensive and defensive strategies. One of the features used to isolate and control the minds of inmates in solitary confinement is to soundproof the cells. There are 2 doors. The outer door is soundproof so the guys can't communicate by yelling to each other through the door. So once again, as with everything, I am left to my imagination. I work out 7 days a week. Wide shoulder, diamond, one-handed, reverse, incline, fist, clap, burpees. I do every kind of push-up imaginable. As many ways as there are to push my body off the floor until I begin developing pain in my elbows. One of the conveniences of my cell is that at all times throughout my workout, the shower is never more than a few feet away. There is a shower stall built into the corner of each cell. I usually wait to take one right after my workout because it is set on a timer and only turns on for 5 minutes at a time each day, cold water. After a shower, I take a little time to clean my cell. I realize that I've developed somewhat of an obsessive-compulsive disorder as I wipe down every surface, whether it needs to be or not. My few possessions all have their specific places. This has become a part of my daily routine, not out of need, but just another activity to burn the time. Every second counts, and every second doing something, anything, is the energy I need to invest to prevent the infection from spreading. It's a constant battle. One day, as I spread my palms out on the floor in prep for my first set of push-ups, out of the corner of my eye, I saw movement and glanced over to see an ant. I immediately scratched the workout and began to tiptoe a mental tightrope. By this time, I was so deprived of any interaction with any human, not only humans, but with any living creature, that the sight of the ant gave me a jolt of excitement. I took a piece of sugar cookie that I had saved from my lunch tray and set it next to the ant. Okay, as I looked over later, I saw that the cookie was completely black with ants. I could actually see the procession, the line of them marching across the floor carrying little crumbs to their home. I lie on my bunk and watch them hours into the night, watching them all work together to break the cookie into tiny chunks and carry them into the crack in the wall. Watching ants race to sugar became a part of my daily routine for weeks. They became my friends.
Ma'am, can you wrap up here?
I am, but I do think this is important, and I've only got a couple more minutes. I realize time is critical here, but I think we all need to hear this.
Okay, I'll give you 2 minutes, then I'll have to cut you off.
Okay, there is no clock in the cell to tell time. Time starts to merge, and there were many days I completely lost track of time, not to mention the date. I've spent the last 19 months in solitary confinement, and with one more month to go, these are the things I had to do and have to continue to do to survive. It's a daily monotonous routine that not even most people who've been locked up for years can relate to. By this point in my bid, I had become familiar with being in a cell, but nothing could have provided me for such isolation and silence. I have become so lonely that I didn't even notice that I'm holding deep conversations with my own thoughts. I listen to what they say as if my thoughts are being spoken to someone else. I have no one to hold a conversation with except for myself. This is the place, the state of mind, the precipice where mental illness is born. Your thoughts will sooner or later begin to drive you mad. As in some cases, a crazy, wacko nutcase. I saw a man that I had known to be perfectly sane before coming to solitary confinement crack under the pressure of isolation. Men who once returned to the regular units needed to be strapped to chairs as they screamed at the top of their lungs. Men rubbing feces on their head, greasing their scalps with shit because they think it will make their hair grow. This is the type of men that isolation creates. Broken men. They succumb to the infection, and some people may feel that some of the things I did are crazy as well. But the things I did to survive. I tiptoed that thin line that separated remaining sane from becoming insane. At times, I may have hopped back and forth across that threshold, but I've managed the infection and avoided completely losing my mind.
Thank you. That's about it.
And that's, I'm in.
All right.
Thank you so
very
much.
Commissioner, could I have you come up? It's going to be the end of the public testimony. And then the commissioner, I need you to just answer a few questions. Just to put you on the spot a little bit, as usual. When that first came out in the paper about the segregation and the 4-part series or whatever, you had responded and with, some of the concerns, but you thought that, you were taking care of it as best you could, and you had some ideas, a step down or this or that and things, but it seemed like you had it in hand. But now we get a huge fiscal note with the governor's budget. I think 25 people or something for segregation alone, and a large fiscal note. So I'm wondering how that came to be, from thinking it was going okay or maybe some minor changes in programs, but to this huge request for the FTEs and the money.
Mr. Chair, Tom Roy again. Sitting to my left is Mary McComb, our segregation project leader, and she's available to answer questions also. In response to your question, we do have in the governor's budget, a request for additional staff to work on this initiative, significantly less than the fiscal note that was earlier referenced in this hearing. There is a gap, and clearly we understand that the amended version of this will result in a different fiscal note. But a couple years ago, we engaged in a very thoughtful process to adjust our segregation services, our policies, our strategies, and related to that initiative, we found that we can benefit by increased staff, not only in our behavioral health staff, but also our security staff related to our segregation restrictive housing initiative. We know we can't do this work without resources. It's a very labor-intensive initiative. Other states expand services. Other states designate new facilities to deal with this. We think our request that's contained in the governor's budget is fairly conservative, and I think the fiscal note that is related, perhaps even in a reduced fashion with this amended version, our request might be less even than that. So we hope and we don't expect to abandon our request, and I think that's the best explanation I can give you at this time.
Okay. So the, your approval of 742, or have you taken a position on it, or?
Mr. Chair, there are elements of this proposal that we are already doing, and I think Mr. Stewart referenced those sections. This, to a degree, is a work in progress for us. We're a bit concerned that the statutory language may or may not align with our dynamic process that we're engaged in. We have some subject matter experts with the Vera Institute. We're getting technical assistance from them, and I'm a bit concerned that some statutory language might, without budgetary support, might drive us into a situation where we cannot comply with statute. Typically, operational policy is kept within our agency policies rather than in statute. And there are certainly many things within this proposal that we can live with. We think it's excellent that we have to report out, and we fully plan to do that. We are in a graduated sanction mode already. But it is, I don't want to say premature to form statute around the effort, but I would have to have your total reliance on our initiative, that we are going to go down a road that is more positive for these offenders. And whether that involves statute or not, I guess you folks will figure out.
Commissioner, would it be safe to say that we'll probably never end segregation or solitary confinement, but we could do the best we can to manage it and make it less stressful on the, I mean, is there any way to?
Mr. Chair, I think as sad as it is to say, there will always be a need for restrictive housing. I wrote a summary comment in the white paper response, and all of you have received the response in previous weeks, and I'm going to read one paragraph that I think summarizes, and I'll be real quick on this. While those going through our justice system are deemed to be competent, there is no similar assessment that they are willing, motivated to live positively once they arrive in our facilities. Even if such an assessment were done, it would be meaningless. They will walk through our doors regardless of their status. We have no choice but to take the worst of the worst. Luckily, most offenders comply with their sentence and the rules in our prisons. Unfortunately, there are a few who choose to remain outside of our rules and our laws. For those that do comply, take advantage of our treatment, our work, the study that we allow them to take in schools, and but there will always be those that function outside of the rules and law. Even the states that are held up as models for segregation reform, every state admits that they will have a need for segregation. It will not be eliminated. Staff safety will always trump the decision. I will not have dangerous offenders assaulting staff. Their work is tough enough. At $17.17 starting wage per hour for corrections officers in the state of Minnesota. Their work is tough enough.
Okay, thank you, Commissioner. Before we move the bill, Representative Hillstrom will get the last question.
Thank you, Mr. Chair, and this is a statement. So, Mr. Chair, first, are you moving the bill out of here today, or are you leaving it here for possible inclusion? What's your intention?
We're laying over for possible inclusion.
Thank you, Mr. Chair. Representative Zerwas, I appreciate the work that you're doing on this proposal, and Commissioner, I appreciate the work that you're doing to attempt to deal with this issue prior to the legislature acting. But this is a very serious issue, both for staff safety and for long-term staff safety, because ultimately the offenders that make it out of solitary confinement worse than they went in also pose a risk for staff safety. So the request that I have is, Commissioner, if you could let us know which pieces of Representative Zerwas's bill are consistent with what you're doing already and best practices, and which pieces you think may not be consistent. Ultimately, I know Representative Zerwas wants to make sure that at the end of the day we end up at best practices. And so we want to give you the ability to do that, but we want to make it clear that we have some, we have an expectation. And so I want to make certain if we could get something from you so that we're clear where you think Representative Zerwas has it right and where you think it's inconsistent with best practices.
Mr. Chair, Representative, I can answer that question right now. It is all consistent with our initiative.
Okay, thank you very much. And Representative Zerwas.
Mr. Chair, real briefly.
Close.
I'll close in brief. We know the bill, and even with the DE amendment, there is nothing in this bill to suggest that Minnesota will do away from restrictive housing segregation or segregation. That's never been my message. That's never been the bill. The bill talks about making sure that we treat people, especially people that are struggling with mental illness, like we would treat any other person confined as a part of our prison system. If someone had chronic hypertension, if someone had cancer, if someone had diabetes, or any other medical condition, like a mental illness, we wouldn't put them in the equivalent of a bathroom for 300, 400, 500, or 600 days. We wouldn't. We just wouldn't do that to people. And so while I understand that the bill is expensive, and while I understand that some people are a danger, I don't doubt that. But the fact that we have people that are being put in isolation for up to 2 years or longer, and there's nowhere in state statute that ever gives them the authority to do it. That is wrong. That is just wrong. We can find a compromise. You heard the commissioner say most of this stuff they're already doing. So let's make sure. If all we're doing is making sure, then it should be easy. So that's the bill. I look forward to continuing to work on it and getting the pieces that we can included in the omnibus. Thank you, Mr. Chair. With that, I'll renew my motion.
Okay, Representative Zerwas, with that, we lay the bill over as amended for possible inclusion in the omnibus bill. Meeting adjourned.